All right, everyone, welcome to week 8. We are now solidly halfway through the semester and two-thirds of the way there. So we are getting close to the end. And I know, of course, this means thoughts and fears of assessment as well. Depending on when you're watching this, we have our assignment 2 due relatively soon. So on the 16th of September, which is this next week, my time. So please get in contact with me if you have any questions about the assessment. Like I mentioned a couple of weeks ago, I put some slides around how to approach a memo from the perspective of international law in the assessment page. It might just be a little bit buried, either halfway or three-quarters of the way down, but hopefully you'll be able to see those slides there, which will give you some hints and tips as to maybe, how to approach these memos for the purposes of international law. Again, email me if you have any questions. Another important deadline too is for your third assessment, which is our moot. So the deadline for getting into groups with that is the 20th of September. So please make sure you find a friend who you can do the moot with relatively soon. After that date, Dr. Rigney will just put you into a random group. So please make sure to try to get one organized if you can. But if not, it's not a big deal. We can just allocate you as needed. We'll also be releasing more information on that assessment on the 15th as well. So being the Monday coming for me. We will let you know what is going to be the moot scenario. And also for next week, which is week 8, so the week that we're going to be looking at this content in tutorials, I'll also be recording a brief lecture on how to approach the moot as well. So things that you should think about, technicalities and procedural aspects of the moot as well, and hopefully preparing you for that third assessment. It's obviously a few weeks away, and I know everyone is really busy with assessment pieces as well, but I'll make sure that information is there for you to review when you're able to. And just a reminder as well, for the next few weeks, we really only have, I guess, 3 weeks after this one of actual in-class tutorials and doing content. Just do your best to get along to these as much as you can. They're obviously, important for going through the content. I do have some hopefully fun activities planned as well. And it'll also be a great opportunity to get to know your colleagues more, work alongside potential moot partners as well, and all around a great thing to come to. But I also understand, especially probably this particular week, we'll be looking at Law of the Sea, that it might be a bit challenging because I know the second assignment is due this week too. But anyway, these are my broad announcements that I just wanted to note before we get started. And I just want to just triple check that I'm actually recording. Yes. And we'll now get into the content in more detail. So this is the Law of the Sea. Last week, we were looking at international environmental law. And so this week on Law of the Sea is relatively similar in some senses. And there's certainly some overlap in these two particular topics, which I'll point out a little bit later on. So, just like a lot of topics in international law, none of them are totally distinctive or in silos from one another. And Law of the Sea is one that integrates a lot of different concepts in international law, including our international environmental law, including issues about sovereignty and so forth. So there are a lot of intersecting, overlapping issues, which we'll try to point out as we go through this. These are the points that we're going to be going through. And again, I've tried to match this up with the headings of your textbook, so hopefully you can follow along. And just like I say most weeks as well, I'm trying to go through relatively similar beats as the textbook, but bringing slightly different perspective to it, some slightly different information, broadening some points where necessary, but also letting the textbook speak to topics in more detail where it does that very well. So, again, I'd recommend having a look at the textbook and then approaching this lecture, and hopefully that will help congeal some aspects and concretize some points of learning as well. So let's start with the origin and the more of the history aspects of the law of the sea. Um, and you'll also find when we're talking about the law of the sea as well, and the significance of it, and I guess why we're studying it too, is that it's a really important resource for states and even corporations to undertake cooperative endeavors, as well as asserting their own interests and authority in relation to the ocean. And we've obviously had some highly publicized issues around the law of the sea and who owns certain aspects of water, especially in the South China Sea, which has been very well publicized in recent years. So the law of the sea is, when we're generally thinking about it, it's about, well, how can states and also corporations and other actors cooperate and also assert their authority in different parts of the sea. And this broad area of the law of the sea has been noted as one of the really important aspects of international law from what many have conceived as the beginning of international law. And, in our first week, we went into the broad history of international law, and the law of the sea very much speaks to that as well. Even though it actually has remained kind of uncodified for a very long time, comparative to when it was an issue. So, obviously the law of the sea has been an issue for hundreds of years, especially when you think about, colonial enterprises, various European empires vying for control. But as we'll talk about, and as you can see already on this slide, the codification of the law of the sea is only really something that's happened in the 20th century. And prior to the first bullet point that I have here, the Hague Conference for the Codification of International Law, which was in 1930, the law of the sea broadly referred to a collection of different customs that various nations observed in relation to the ocean. And these varying, intersecting, and differential customs became topics for debate at this initial Hague Conference for the codification of international law. But the conference actually concluded without producing a law of the sea treaty due to various disagreements on the question of the breadth of the territorial sea and other intersecting issues. After World War II, the United Nations then conferred the first conference on the law of the sea, which we also know as CLOS 1 in Geneva in 1958. And there's four different conventions that were adopted at the end of UNCLOS 1. So the United Nations Conference on the Law of the Sea, which was the four that I've got noted here: the Convention on the Territorial Sea and the Contiguous Zone, or otherwise known as CTS, the Convention on the High Seas, the Convention on Fishing and Conservation of the Living Resources of the High Seas, and the Convention on the Continental Shelf, or CCS. And there was also the adoption of an optional protocol of signature concerning the compulsory settlement of disputes as well, though at that time many states refused to ratify that particular document on the settlement of disputes. And we'll talk about dispute settlement a bit later on in this lecture as well. And at this stage, for CLOS 1, these conventions didn't actually even more broadly achieve a high number of ratifications. And so a second UN conference on the law of the sea, or CLOS 2, was needed. And this was convened in 1960. So really only just a few years later, in order to address these different questions that were causing difficulty in that first conference, such as the breadth of the territorial sea and the settlement of disputes, which had been unresolved. There was still sharp disagreements at this stage over those questions, and so CLOS 2 did not actually produce any substantive treaties in and of itself. And At this stage, we have to also think around 1960s and onwards. There were broader geopolitical and political developments which impacted the negotiations around the law of the sea and the broader field as well. As we know from our previous discussions, especially around self-determination, there was a quite large number of states that had started to gain their independence from imperial and colonial rule. And these states had been unable to send delegates to the Conference of the Law of the Sea 1 and 2, and felt that many of the provisions of these four Geneva Conventions I noted didn't reflect their needs and issues as newly developing states, newly independent states, and they especially sought greater control over fishery resources, mineral resources in areas that were beyond their immediate national jurisdiction, like in the ocean, for example. There was concerns about the preservation of their marine environment and national security threats that came from the ocean, as well as other technological points that these newly independent states who had struggled against imperialism and colonialism were concerned about. And the Geneva Conventions were also problematic too, because they still hadn't determined the breadth of the territorial sea, which, as we'll talk about a little bit later, is a very important point of the law of the sea in general. And around defining the territorial sea, the kind of dispute at this particular time was that the newly independent states wanted a wider territorial sea from their own states, so they could then have more operational control, for example, while former imperial powers wanted to keep the territorial sea as narrow as possible so that they could preserve their vast geographical scope of international waters or the high seas, so that these previously imperial and colonial powers could have the whole seas to move in without any interruption. So, with these kind of disputes and points of difference in mind, the newly independent states, as well as the former imperial powers, agreed to a third conference on the law of the sea, which ran from 1973 to 1982. And there was the desire to try to produce some kind of universally, singly ratified ocean treaty, which states would not be allowed to make reservations or exceptions. And so ratification of this treaty would mean that states are signing up to this ocean treaty as a single package. And these different groups of the newly independent states, the imperial powers, they both recognize that this topic of the law of the sea was really important and formed an intersecting area in which there was going to have to be compromises between lots of different competing interests, and which was also important to find some common ground on in a potential future ocean treaty. And CLOS 3, the Conference on Law of the Sea number 3, adopted provisions through a combination of consensus and majority voting, with an attempt to try to stop recalcitrant states from blocking emerging consensuses on different points of law. And so by the end of the conference period in early 1982, the third UN CLOS was adopted by 130 votes in favour, 4 against, and 17 abstentions. And then it entered into force finally 12 years later in late 1994. And as we will talk about more relatively soon, UN CLOS adopted a zonal approach to the ocean. This third treaty had a zonal approach to the ocean that divided waters into maritime zones with very specific dimensions. The treaty also codified rules on innocent transit, as well as archipelagic types of sea lane passage. And this focus on the archipelagos was also a very distinctive contribution of this third conference to this broader kind of grammar of international law as well. Mm. So let's talk a little bit about these maritime zones in the moment. Just one second. All right, so these coastal state maritime zones. Um, Apologies about the brief interruption. So, as we were mentioning, the UNCLOS Third Treaty was the broader, really vital and important treaty that is governing international law regulating ocean spaces now. It's now been ratified by 168 states with Azerbaijan, I think, being the most recent, and it's considered to be a successful codification of customary law that had existed for quite, a long time. And I will talk about that history a little bit later on as well, especially when we consider the high seas. Um, and even world powers who have not ratified the UNCLOS, like the United States of America, still consider it customary in nature, with the exception of Part 11 of the convention, which goes into the deep seabed, or otherwise known as the area, which has been quite controversial. And for the most part, UNCLOS sets out how states are entitled to use various parts of the ocean, alongside the various jurisdictional regimes that relate to the various ocean regions, which we'll touch on one after the other here as well. And the so-called Ocean Treaty, UNCLOS, was also responsible for a significant reduction in the scope of the high seas. This, concept of international waters, which we'll touch on soon, which was on the back of a more expansive concept of the territorial sea, as well as the creation of exclusive economic zones, and also of the archipelago waters for various islands and island water formations, which represented somewhat of the power, or at least emerging power, of the post-colonial states when UNCLOS 3 was negotiated. So we'll now go through each of the broad categories of different waters that define the maritime zones. I'm going to start with internal waters, which is obviously not in the maritime zones per se, but internal to the states. And then we'll have a look at, well, what are the baselines? Where do we start? Then we'll talk about the territorial sea, the contiguous zone, exclusive economic zone, then the continental shelf, and archipelagic waters, before we then look at those zones beyond national jurisdiction, such as the high sea, such as the area. So this is what we'll be going through one by one. So starting with the internal waters, these are obviously the waters which are internal to a particular state's territory, and after the baselines of the state have been established. I'll talk about these, what these baselines are very soon. Article 8, subsection 1 declares of the CLOS UNCLOS, that all territory on the landward side of the baseline, so the baselines are where, where the land meets the sea, basically, that constitutes the internal waters of a state. Um, uh, and there's some exceptions to that within Part 4 for archipelagic states, which is kind of a little bit different. But for the coastal states, there's internal waters, and the states with internal waters exercise full territorial sovereignty over them. Um, with the real primary difference between internal waters on one side and the territorial sea on the other are that internal waters are not subject to the various rights that vessels and ships have and that they possess when they are in the territorial sea, for example. Um, and so, with very few exceptions that are noted in Articles 27 and 28, which aren't too crucial to delve into, the internal waters of a state operate more or less legally in the same manner as the state's landed territory. So, this is kind of our first main focus of watered areas for the law of the sea. It's our internal waters. Now, baselines is the next part we'll now go into. Um, and baselines form the kind of basis for separating out the different zones of jurisdiction that is at the center of UNCLOS, because all the subsequent ones start from the definition and the premise of maritime baselines, and hence the name, baselines. Um, as a concept, they're just basically, as I mentioned before, the demarcation or the separation point between on one side what's considered the landed territory of a state, and then on the other what is considered to be part of the ocean, which is then governed by UNCLOS. So basically, where the territory meets the water. And the starting point for determining, well, what is a state's baseline, and this applies in most circumstances, is in Article 5. And this states that the normal baseline for measuring the breadth of the territorial sea is the low water line along the coast as marked on large-scale charts officially recognized by the coastal state. Um, and this was relatively, when the time when this was being negotiated, this was relatively uncontroversial as a standard for demarcation geographically for most states. But there were additional rules about determining baselines for non-standard coastlines, which are things like reefs, which kind of fringe on the territorial area, coastlines with like deep indentations, or with like fringing islands, or entirely enclosed bays. Articles 6, 7, and 10 were developed with additional rules for determining baselines in those situations. So Article 6 talks about that the baseline can be drawn from if you have like a reef fringing on the territory, you can, Article 6 talks about drawing the baseline from the low water line of the reef. Article 7 then sets out rules for drawing straight baselines to allow for an easy maritime zone measurements where the coastline has like deep indentations or there's fringing islands off the coastline. And then if you have an entirely enclosing bay, Article 10 then talks about, well, here are the rules for determining baselines in that particular situation. Then once we've determined the baselines of the state, established in these manners, and there's some delimitation drawn, then the state is required to publish these charts and then deposit a copy of them with the Secretary General of the United Nations. Um, and it's probably worth also noting, which kind of speaks back to our discussion from last week in week 7 with international environmental law and climate change, that it's generally accepted that baselines move as the coastline changes, as a general sense. But with climate change causing a significant sea level rise, potentially the reduction of coastline, especially for our small island states, which we've spoken about, there's quite a strong legal argument, which is still kind of in development, on based on equity concerns about actually fixing baselines rather than allowing baselines to move as coastline changes, because that would obviously then especially affect states which are most at risk from climate change. So once we've got our baselines, the law of the sea then divides maritime zones into uh, broader categories, and we'll go through our specific subcategories, but which I mentioned earlier. But these specific subcategories are also within broader categories of zones of sovereign control, zones with sovereign rights, and then areas beyond national jurisdictions. And this is our high seas, for example. So let's talk about our first subcategory, which is where states have some sovereign control. Let me just progress our slides. There we go. And all right, so the territorial sea is our first subcategory we'll touch on. And this is the first one that exists past the baseline of a state. And historically, and we'll talk more about the history a little bit later on, but the territorial sea had been typically set to a limit of 3 nautical miles from the baseline. And this limit was then updated in the drafting of UNCLOS to a maximum of 12 nautical miles, which actually closed a quite important historical debate in terms of the breadth of the territorial sea. And just as I mentioned before, both at the Codification Conference of 1930 at The Hague, as well as the Geneva conferences of CLOS 1 and 2, there was not an answer found to this particular question about the breadth of the territorial sea, and it was only really with the increasing power and representation of states coming out of colonialism, out of formal colonialism, that there was a push to then answer this question and to then expand the territorial sea. And just like the internal waters of a state, which we've mentioned, we can think about the territorial sea as basically almost being quite similar in that the state has full sovereign territory it has full sovereignty over this territory of the territorial sea of 12 miles past their baseline. And the primary kind of difference between the two, as I kind of hinted at when we're talking about the internal waters, is that there are obligations of states which are owed to foreign flagged vessels within the territorial sea. And the general right that vessels of all states possess in territorial seas is the right of this idea of innocent passage, which is guaranteed by Article 17 of CLOS or UNCLOS. And then the actual details of what does innocent passage mean is then set out in Articles 18 to 26 of UNCLOS. And generally speaking, this idea of innocent passage is the right to continuously and kind of quickly transit through the territorial sea, which isn't prejudicial to the peace, good order, or security of the coastal state. This also means for submarines, which are generally below water, they need to emerge, and they must travel surfaced with their flag displayed. And also for vessels operating under some kind of nuclear power, they have to carry documentation that makes this known, and then follow precautionary measures for their innocent passage through the territorial sea. And if we break down, well, what does innocent passage mean? This has often been a source of debate because of foreign flag vessels moving through territorial seas. It's often questioned, well, are they meeting the requirements of innocent passage? And for these purposes, generally passage means some kind of navigation through the territorial sea, which is for the purposes of traversing that sea, importantly, without actually entering the internal waters or stopping at a harbour or a port facility just outside of these internal waters. Um, and this is under Article 18 of the UNCLOS, or the Law of the Sea. And passage must be continuous and expedited, and with stopping and any anchoring must be incidental to ordinary navigation, as Article 18 also discusses, not stopping and anchoring just because they want to, or for any other purposes outside of just ordinary navigation. And then what innocent means, this is kind of quite briefly put in the convention under Article 14, where it says passage is innocent so long as it's not prejudicial to the peace, good order, or security of the coastal state, as I noted, and such passage shall take place in conformity with these articles and with other rules of international law. And the convention further provides that passage is not innocent if it violates fishing laws, for instance, of the coastal state as well. So if a ship is moving through territorial waters while it's fishing and doing so in a way that violates the fishing laws of the coastal states, then that isn't going to be innocent passage. Now, there's other restrictions on coastal state sovereignty within the territorial sea. And this is limitations on criminal and civil jurisdictions being exercised over foreign flagged vessels, which is linked with Article 92 of UNCLOS, which grants exclusive jurisdiction to the flag state over vessels on the high seas. And because the Convention of UNCLOS treats vessels as basically, or boats, as an extension of the territorial jurisdiction of the flag state. So, the flag state meaning the flag represented on the boat's masthead, for example. So, if we have an Australian ship out, past the territorial zone of Australia, maybe it's around the United States or something like that. The convention generally treats vessels as an extension of the territorial jurisdiction of the flag state, so of Australia in that particular example. So then there's some jurisdiction limitations around criminal and civil law for the coastal state which the ship is near, and Articles 27 and 28 of this UNCLOS talk about them respectively, for criminal in 27 and 28 for civil. Now, the contiguous zone is a zone, as is hinted by the name, which is contiguous to the territorial sea, so kind of right next door, in which the coastal state may exercise kind of certain powers for the enforcement of different areas, such as in customs law, fiscal law, sanitary law, and immigration law. And according to the Law of the Sea Convention, UNCLOS, the contiguous zone cannot extend beyond 24 nautical miles from the baseline from which the breadth of the territorial sea is measured. Uh, and this contiguous zone has its like kind of historical origins in special jurisdiction zones which states variously claimed at different times throughout history. For example, the British adopted a series of acts in the 18th and early 19th century, and these were called hovering acts, which claimed jurisdiction over ships that were suspected of smuggling within different limits from the coastline. And similarly, another example, the United States had an act in the early 1900s called the Tariff Act, which subjected foreign ships to American laws on the prohibition of alcohol within 12 miles from the coast. And France also fixed the limit of its revenue jurisdiction for tax purposes at 20 kilometers in the early 19th century as well. So this idea of the contiguous zone has some historical connections to the various practices by states of extending certain laws past their actual their landed territory. And in the UNCLOS, it says in Article 24 on this particular point, in a zone, and I'm quoting here, in a zone of the seas contiguous to its territorial sea, the coastal state may exercise the control necessary to prevent infringement of its customs, fiscal, immigration, or sanitary regulations within its territory or territorial sea, punish infringement of these within these regulations, which is committed within its territory or territorial sea. And this was also reflected similarly in another article, Article 33 at the third UN CLOS conference as well, which reflected more or less these points, except that rather than the historical practice of having the 12 miles, it fixed the 24 mile point as well. And there has been a lot of discussions about like adding security within these regulations as well. But it generally has been found that, if there's an addition of the ability for states to enforce their security interests within that area, then that might be too broad and then too indefinite. For example, and we've seen issues of this, indefinite nature of security concerns when we're thinking about like sovereign territories, for example, of states where you have like direct and indirect control of nationals, for example, which then it was worried that those kind of ideas of security regulations being brought into the contiguous zone would also then extend the potential jurisdiction or interests of the state in security to very, very broad areas, which would not be tolerable by the broader international community. Now, the third subcategory of areas that I have here on this slide is the exclusive economic zone. So this is also usually shortened as EEZ, very commonly. And this is created in Part 5. And these are basically where the area in which the coastal state has exclusive economic rights. And this is a really important part of the UNCLOS. And this is exactly a point where there was a lot of deliberation about creating a balance between, on one hand, the economic interests of coastal states, and especially those of so-called developing states, and then on the other hand, the maritime and strategic interests of other states who are generally the, larger world powers who had interests in broader regions outside of their own. Um, and typically, the convention is seen to give coastal states sovereign rights over the natural resources found within a 200-mile limit of this exclusive economic zones. Um, but these rights in this zone of the coastal states within the exclusive economic zones are primarily economic. Um, and then that also means, as we'll see when we talk about the high seas, that there's traditional high sea freedoms are preserved. Um, and I mean, this is a really important point that's worth focusing on here with, around this idea of exclusive economic zones. Um, so from the baseline, it extends up to 200 nautical miles from where the territorial sea is measured. The coastal state generally has the control over resources and over other economic activities in this zone. And they also have uh, generally been given, these coastal states, other competencies which go strictly beyond a sovereign control or rights over resources, which also includes the jurisdiction with regards to the establishment and use of artificial islands, for example, different installations and structures, jurisdiction around maritime scientific research, and also the protection and preservation of the marine environment, which we'll also talk about a little bit later on. And then other states also have some recognized rights within this exclusive economic zone, or EEZ, which actually more broadly it's seen to be more broadly belong to the international community as a whole, as compared to, or as distinct from, perhaps the coastal state in and of itself. So all states enjoy a freedom of navigation and overflight of through these exclusive economic zones, as well as the freedom to lay submarine cables and pipelines too, and other internationally lawful uses of the sea that relate to these kind of freedoms, which relate it to the operation of ships, aircrafts, as well as like putting in submarine cables and pipelines. Um, so it is a slightly specific regime, which is a bit different from the territorial sea. It's also a bit different to the high seas, kind of having and holding characteristic features of both, even though it doesn't strictly fall into either of them. Um, and they'll become more clear when we talk about the high seas as well. So, and again, this is the point that we will come to a little bit later. Even though coastal zones have the rights over certain living resources of these exclusive economic zones, that also means with those rights they have duties. And this usually relates to the conservation and management of these resources, and especially with fisheries, which again, we discuss a little bit later on. And the coastal states have to ensure that these resources, these living resources, in the exclusive economic zone aren't endangered by overexploitation. And so there has to be conservation and management measures instigated by the coastal state, which ensures that the population of harvested species are maintained or restored. That can ensure that species continues producing the maximum sustainable yield, which is conceptualized in terms of not just economically, but environmentally as well. So there's also not only rights, but very specific duties around the resources in the exclusive economic zone. A state can't simply just go in and absolutely decimate all of their fish or coastal life, for example. And if the coastal state doesn't actually have the capacity to make use of the economic resources, or for instance, if it doesn't have the capacity to harvest an entire kind of economically and ecologically allowable catch, there's actually an obligation to give other states access to like a surplus of this kind of allowable catch. It's not automatic, must be subject to agreements and different arrangements that are between states. Uh, but if a coastal state is going to give access to other states for their living resources in these exclusive economic zones, it has to also keep in mind to the ecological aspect and the management of the resources aspect as well. So these are important considerations that we'll also turn to when we look at fisheries and maritime environmental protection. And also another thing just to mention for the EEZs as well, that the coastal state also has some rights of law enforcement relating to those rights it has within the EEZ, where Article 73 requires that these resources are managed if they're overlapping in different EEZs, for example. So if there's two or more EEZs overlapping, or it's overlapping at the high seas, then there's requirements for those resources to be managed through different mechanisms. This Article 74, 73 and 74, sorry, talks about enforcement measures as well as requiring equitable agreements and solutions with managing resources in the EEZ as well. So now let's go on to our final two main parts of these coastal state maritime zones. The first one of these two is the continental shelf. And this is focused on by UNCLOS Part 6, which sets out the rights of states over the continental shelf. And this is the area of the ocean floor seabed and the subsoil. And this continental shelf of the coastal state, very similar to the EEZ, is typically limited to a maximum of 200 nautical miles from the baseline of the state. But Article 76 does provide some grounds where states can claim an extended continental shelf. And there is a mechanism in UNCLOS whereby a commission has been established, which is called the Commission on the Limits of the Continental Shelf, that is supposed to kind of help with the application of the rules about extending a continental shelf if any state wants to do that. And this is important because the continental shelf grants quite similar sovereign rights to the coastal state that the exclusive economic zones does, except relating to the resources of the seabed rather than in the actual ocean itself. And while the exclusive economic zone needs to be claimed actively by a state, the continental shelf is considered an inherent right of the coastal state and almost an extension of the landed territory. Now, our final one here, which is the archipelagic waters, and I hope I'm kind of saying that right, Brian, relating to archipelagos. This is a category of waters which forms the definition of an archipelago in Article 46B of UNCLOS, which is a group of islands, including different parts of islands with interconnecting waters, other natural features, which are so closely interrelated that such islands, waters, and other natural features form an intrinsic geographical, economic, and political entity, or which has historically been regarded as such. And then Article 47 of UNCLOS steps through the requirements whereby an archipelagic state might draw its archipelagic baseline that joins the outermost points of the outermost islands and drying reefs of the archipelago as well. And the waters that are then encompassed within these baselines drawn by the archipelagic state are the archipelagic waters, except the waters that the archipelagic state might delimit as internal waters, as we've spoken about previously. And these archipelagic waters are subject to the sovereignty of the archipelagic state, regardless of the depth of those waters or even the distance from the coast. The sovereignty over these archipelagic waters, though, is subject to a few limitations. So, an archipelagic state, for example, is under an obligation to respect existing agreements with other states and to recognize traditional fishing rights and other legitimate activities of immediately adjacent neighboring states in archipelagic waters. And archipelagic states are also required to respect existing submarine cables laid by other states and to permit the maintenance and replacement of those cables as well. And very similarly to what we've spoken about previously, there's two regimes of passage relating to archipelagic waters. These are firstly our innocent passage, which we've discussed before, as well as another regime called archipelagic sea lanes passage. And just like our territorial waters, which we discussed before, ships of all states have this right of innocent passage through the archipelagic waters, subject to the right of archipelagic sea lanes and the passage of them, and without prejudice to the right of the archipelagic state to delimit internal waters as well, which is important. But the archipelagic state does have the ability to suspend this innocent passage without discrimination among foreign ships when it's essential for the protection of its security. Whereas the right of archipelagic sea lanes passage has evolved historically from the right of transit passage through international straits. So just like states that kind of straddle the straits, that's STRAIT straits, archipelagic states can designate sea lanes and air routes for that continuous and expeditious passage of foreign ships and aircraft through or over these archipelagic waters. So where the UNCLOS guarantees this right of innocent passage through archipelagic waters to ships of all states, quite interestingly, it only states that all ships and aircraft enjoy the right of archipelagic sea lane passage in such sea lanes and air routes as the archipelagic state may designate in Article 53, subsection 2. And when a archipelagic state wants to designate sea lanes and a certain traffic separation schemes in their archipelagic waters, they also have to seek approval from the UNCLOS governing body as well. So there's some, technicalities around the archipelagic waters. Now, the high seas are a really interesting part of sea law, and the high seas have a really crucial and central place in the history of international law more broadly. Um, there, excuse me, started to we started to see an emergence of a very distinctive idea of a law of the sea uh, around the time of the 17th century, and it was with the problem of the high seas mostly in mind, because this attracted the most attention in state practice as well as in scholarly work, and this remained the case for many centuries afterwards as well. And even though with UNCLOS, for example, the territorial sea started getting more recognition as a definitive protected maritime zone, um, because it's still relatively narrow, the importance of the high seas has still remained relatively undiminished. Um, and it was only with this idea of the continental shelf, the EEZ, when the dominance of the high seas in the broader law of the seas started to then become, slightly eroded, even though not entirely, because there's still so much of the planet which is made up of the high seas. And it is the largest of the maritime zones. Um, and there still is a lot of characteristics associated with the high seas that is also inherently connected to this vision of a free sea. Um, and we've spoken about that some of those ideas of the high sea freedoms, like the rights of navigation, are preserved in other maritime zones as well, such as the EEZ. Um, and the the freedoms of the sea and the centrality of the high sea to international law more broadly goes back, like I mentioned, throughout history, and is of substantial import because of the historical developments in this area rather. Ancient communities, including the Romans, viewed the seas and oceans as kind of a free for all to access and to sail upon. And it was only once we had stronger naval powers emerge who sought to assert claims not only over coastal waters itself and inlands. Um, they also started to try to assert control to adjacent seas. Though, despite those claims, which is especially prevalent with the European imperial powers, the vast majority of the known seas and oceans were regarded as high seas belonging to no one with significant freedoms. So they were open to all for navigation and fishing. And this idea of the freedoms of the high sea, which is also expressed in a lot of cultural artifacts, as well in terms of stories and books and such, and even in the more modern era in movies and so on and so forth. These ideas of the high seas freedoms were so embedded in the kind of the broader international relations consciousness, if you might say, that any kind of variations were an incredibly radical departure to the established legal order. And one of the main challenges that that kind of pushed back against this freedom was in the 1494 Treaty of Tordesillas, which I'm definitely not saying correctly, founded upon Pope Alexander VI, which sought to divide the world, including the oceans, into a Portuguese influence to the east of the globe and a Spanish influence to the west. Which had a significant impact upon thinking regarding the freedom of the seas, because it delineated whole spheres of the planet to the particular strong naval bodies of Spain and Portugal. And this was actually quite interestingly, going back to our week one topic, the setting by which Grotius appeared. And he wrote the book Mare Liberum, which appeared a little bit later, but it was motivated by the desire of the Dutch, who was also then establishing itself as an international naval entity, because the Dutch wanted to maintain their freedom of access to the seas. And Grotius's text and legal work at this time had a really considerable impact on legal and doctrinal discourse on what would become the regime of the high seas, which is obviously, why we still talk about Grotius importantly today. And Grotius was building on principles of res nullius, so things owned by no one, res communis, or things owned in common, and res publica, or public matters. And Grotius asserted through these three principles that the oceans could not be appropriated because they could not be occupied. And as the oceans were therefore not susceptible to occupation and accordingly not capable of ownership by any one state, the oceans, just like the air, were available for everyone to use freely. And so this Grotian idea of the freedoms of the high seas ended up prevailing. But since the 19th century, there's been a very steady and quite gradual reduction in the geographical extent, mostly due to the treaties we've already been speaking about. But it still obviously remains exceptionally expansive, with these areas beyond national jurisdictions still accounting for about 60% of the ocean surface and 90% of the actual volume. And interestingly, too, rather than just the laissez-faire freedoms which may have been associated with Grotius's time, there is more regulation of the high seas as well, and this is particularly due to the conventions that we have spoken about so far as well. So there is some efforts, or has been efforts more recently in history, to enhance ocean management in these areas beyond national jurisdiction and beyond national regulation. So there's been a significant transformation in the legal relations in the high seas through various specialist treaties that deal with like biodiversity, high seas fisheries, whaling, navigational safety, pollution, and maritime security as well. So this idea of the high seas cover all of the areas of the oceans, which are beyond the zones we've spoken about so far, with it being very explicitly clear, going on that Grotian idea, that any claims of sovereignty is invalid over this zone. And Article 87 of UNCLOS sets out the freedoms that are enjoyed by all states and vessels when on the high sea. And this is the freedom of navigation and overflight, freedom to lay submarine cables and pipelines, freedom to construct artificial islands and other installations, which is subject to particular points in international law around the continental shelf. There's freedom of fishing, with still regard, there has to be kind of due regard for other states as well through different agreements, and freedom of scientific research. And there's also some restrictions around the continental shelf and Part 13 on that as well. But these are generally the freedoms which Article 87 recognize. And importantly, too, for our idea of the high seas, and I mentioned this before, but the jurisdiction over vessels on the high seas, for example, belongs exclusively to the state whose flag is being flown. And this is in Article 92. And these flag states of ships in the high seas have duties to maintain a register of ships that are flying its flag, ensure the seaworthiness of vessels, ensure that vessels have appropriate equipment for safety of navigation, and ensuring that there's adequate crew and labor standards on the vessel, and that the crew have appropriate qualifications as well. And this also includes the assumption of criminal jurisdiction over incidents of navigation caused by vessels flying their flag. as well. And the high seas section of UNCLOS sets out different grounds of jurisdiction in which government or warships may engage in various activities. For example, like the prevention of piracy, suppression of slave trafficking, and also unauthorized radio broadcasting. And it also contains the obligation of all vessels to render assistance to those in distress within their vicinity, which are important points as well. Now, the last area here, which is a kind of last maritime area, is the deep seabed. And I'll try and just touch on briefly. And it's also known sometimes as the area. Um, and it's kind of like to the area is to the high seas what the continental shelf is to the EEZ. So it's the kind of the subsoil and seabed in the areas of the high seas that are beyond national jurisdiction. And Part 11 of UNCLOS goes into the area or the deep seabed. It sets up the area as a part of the common heritage of all humankind, so that if there's any exploitation of resources contained within this deep seabed of the high seas, it has to be used for the betterment and benefit of all peoples. And there's the UNCLOS also set up the International Seabed Authority to govern activities being undertaken within this zone. But even today, there hasn't been a lot of commercial exploitation of resources contained within the deep seabed generally, because it's been deemed not viable to really do so. So one area of the world which has so far resisted widespread exploitation, but we will see how long that lasts. Now, connecting our discussion of law of the seas to our previous week's topic, we'll now just touch on, in our last 10 minutes or so, or thereabout, our maritime environmental protection as well as fisheries too. So the pollution of the maritime environment is obviously a real problem, not only because of the impact it could have on human health, but especially because of its impact to the living organisms in the sea. And this has caused states to adopt several multilateral conventions in the modern era to try to prevent and reduce pollution. So the UNCLOS deals with this problem quite extensively in Part 12. And it's generally recognized that states have the obligation to protect and preserve the marine environment. And there's generally three main sources that are recognized of the pollution of the marine environment. First, the release of toxic, harmful, and noxious substances from land-based sources, pollution from vessels, and pollution from installations and devices that are used in exploration or exploitation of the sea. So these are the three areas where pollution might come from. And with respect to the first one, our land-based pollution, there's a Convention on the Prevention of Marine Pollution by Dumping Waste and Other Matters of 1972, which is of real importance for regulating this aspect. And it put this dumping of waste into the sea under some very strict surveillance of coastal states. There's also similarly, in terms of that the second avenue for pollution, the Convention on Civil Liability for Oil Pollution Damage of 1977, which holds the operator liable for pollution damage resulting from incidents. And there's more oil pollution from vessels. There's also issues about oil pollution from vessels more generally, and there's a number of conventions dealing with those as well. There's the International Convention for the Prevention of Pollution of the Sea by Oil, which was signed in the early 1950s, which prohibited the discharge of oil or oily mixtures. And if it was necessary to do so, there's a very strict small amounts of what that could be. which I won't really go into in too much detail, but there's been also the Convention for the Prevention of Pollution from Ships, which has tightened that significantly, which was agreed in the 1970s as well. And then in the late 1960s, there was an international convention relating to intervention on the high seas in the case of oil pollution casualties, because historically speaking, and even, I mean, close now to the modern day, oil spills has been a huge environmental issue. And this treaty was, or convention was negotiated in the face of some particularly bad ones, and it empowered the coastal state to take measures on the high seas that may be necessary to prevent, mitigate, or eliminate damage to their coastline or related interests from pollution from oil spills, for example. So this issue of the coastal state's jurisdiction with respect to pollution control was actually a very contentious issue in the third UNCLOS. And the maritime states, or the kind of naval powers, you might call them, they objected to an expansion of the coastal states' power over their ships for the issues of pollution control. But the coastal state does have legislative and enforcement jurisdiction with respect to the control of pollution from land-based sources and from seabed activities. But in the case of pollution from vessels, the coastal state's power does decrease gradually as the ship kind of moves further and further out to sea, because the primary jurisdiction is vested in the flag state, outside of the conventions I've mentioned before, which do give the coastal states some power to deal with like oil spills, for example. Um, Now we'll turn to fisheries, which is kind of also a related area. Um, and in the early 20th century, the coastal state was generally seen to have exclusive fishery jurisdiction, only in the territorial sea. But then there was a continued demand to widen this fishery jurisdiction on the part of coastal states, and especially again, after movements towards decolonization, the so-called developing states especially wanted to be able to widen their fishery jurisdiction, especially as the century went on and more independent states began to emerge. And after, just like I kind of mentioned earlier, after that second UNCLOS conference, there was a rapid growth for a push for a 12-mile fishery zone. And even by the mid 70s, the International Court of Justice was also ruling or declaring that customary law had been changing even before our third UNCLOS conference, saying that with all these demands of states and state practice, that this concept of the fishery zone, where states can claim exclusive fishery jurisdiction, had extended to a 12-mile limit from the baseline and was generally accepted by states, and that states had preferential rights of fishing even in adjacent waters for the coastal states. And interestingly enough, around this time in the 1950s, Iceland, who's very dependent on fishing economically, adopted a law soon after the second UNCLOS conference, which proclaimed a 12-mile fishery limit around Iceland, with all other fishing by foreign vessels totally prohibited. And then Iceland, about 14 years later, extended its jurisdiction to 50 miles. And the UK was very unhappy about both of these declarations and brought that second declaration before the ICJ. And the court held that Iceland was entitled to a preferential share of the fishing resources in the areas, but the UK also had a right in the same areas, and asked the two governments to kind of negotiate a solution. And interestingly, just a year after Iceland's original, second declaration of their fishery zone to 50 miles, it then said it was extending it to a 200-mile fishery zone. So it started to be kind of shown that this 12-mile limit was inadequate for the conservation of fishing resources. And as we approach the UNCLOS, the third iteration, and under the influence of demands for the exclusive economic zone at this time, the fishery zone limit jumped to 200 miles. So Iceland's kind of a push for this ended up being a kind of a leading light as to how the law would develop. And this is quite interesting too from a statistical point of view. In 1958, only six countries had actually claimed a 12-mile fishing zone. And then by the mid 1970s, there was 20 countries now claiming a limit that range from 15 to 200 miles. And then by the early 1980s, there was 25 states claiming, 80 states claiming a 200-mile fishery zone as well. And so most legislations that respect fishery zones claims for the coastal states' exclusive jurisdiction include the exploitation of living resources like fish, marine animals, and plants as well. Foreigners generally may be allowed to fish in the zone with the permission of the coastal state on the basis of agreements. And it's also generally seen that in these kind of agreements, traditional fishing rights should be considered and respected as well. Uh, and kind of talking about this necessity for agreements kind of is a nice segue to our final point before we finish up, which is of dispute resolution. Because the UNCLOS gives states an opportunity to settle their disputes as well by peaceful means of their various choosings. And this is actually seen generally to be quite an unusual system of dispute resolution in international law, because in most other instances, dispute settlement depends on whether states agree to submit their dispute to an international court or tribunal, as we've seen, like for instance, with the ICJ. And if the states don't agree on the mode of dispute settlement in UNCLOS, there's procedures outlined in Part 15, which provide that recourse to further procedures is not excluded. And it talks about that there's binding decisions which can be made under the International Tribunal for the Law of the Sea, as well as the International Court of Justice, as well as an arbitral tribunal, which is also constituted in accordance with UNCLOS. And there's also another special arbitration and tribunal for disputes over fisheries, as well as the protection and preservation of marine environment, marine scientific research, navigation, and marine vessel pollution and dumping. So there's quite multi-layered and unique aspects of dispute resolution with UNCLOS. So I think we might have come to time now, and this is all that I wanted to touch on. Again, hopefully just expanding some of those points around the law of the sea that your textbook went into in a lot of really good detail as well. We, of course, have our tutorials coming up as usual in week 8. Please make sure you come to the correct class as well. I look forward to seeing you all there. And good luck with the assignment work as well. And thank you very much for tuning in, everyone. All right, and goodbye.